Hey, Nate Webb from the Webb Law Firm in Bellevue, Washington. WebbAttorney.com, W-E-B-B attorney.com. Also SeattleDUIPros.com. Here to talk to you today about speedy trial. What is speedy trial? Well, in King County, I think all my colleagues who might be watching this video would probably laugh because speedy trial is really non-existent. There's a court rule called time for trial, and it's called CRRLJ 3.3, which is Criminal Rules for Courts of Limited Jurisdiction 3.3, and it establishes what speedy trial is. Speedy trial is a constitutional right under both the United States Constitution and Washington State Constitution, and essentially what it is a limit on how long the government has to bring your case to trial once you have been formally charged under what we call an arraignment, wherein you're told what the charges are against you and you enter a plea. So from that time forward, if you are out of custody, not being held in jail, as a criminal defendant, you have 90 days in which the state or government would have to bring you to a jury trial. If you're in custody, it's 60 days. However, in King County, there is something really unique going on under the rule, which enables a court to basically give the state or government an additional 28 days if it chooses to. But before we talk about what's called the cure period, which that is, let's talk about the nuances to the speedy trial rule. So I have a lot of people that say, hey, is this case going to be over within that 90-day period? And I say no. It's not very common. There's so many exceptions to the rule that the Supreme Court has basically made it superfluous. There's many ways to get around it. There can be excluded periods, continuances for good cause, continuances for other matters in the court's discretion. So essentially it is really not existent any longer. And now in King County there is an increasing backup or backlog of DUI cases because there's a new policy that's being implemented that no DUI is going to be reduced no matter what the circumstances, no matter the evidence the state may lack, and it's not going to be reduced. And so there's an increasing backlog because there's just no way with the limited number of courtrooms and prosecutors that the state has in King County specifically to handle all those DUI cases. And so now 40 people want to go to trial 1 week and there's only one courtroom, and so the court now has taken it upon itself under that criminal rule I was talking about, 3.3, time for trial, 3.3G specifically, is called the cure period, and it says the court may, in its discretion, basically give the state an additional 28 days if you're out of custody or 14 days if you're in custody. So there's a key word there that says may. The court, in its discretion, may do this, and so they're certainly not required to do that, but they may. And the first part of the Rule 3.3 says that the court is responsible for getting basically cases to trial on time, and so the court to take the position that they're always going to give an additional 28 days under the cure period, I think is an abuse of discretion, respectfully, if any judges are watching this. It should only be used in certain circumstances in extraordinary cases, but not normal cases, and so this is really becoming the norm in King County. But the whole video here is about what is speedy trial. That is speedy trial. It's a constitutional right you have to be brought to jury trial within a matter of time so that the case can't just be hanging over your head and they just get you when they feel like it. But there are many ways around it. I mean, I've even seen, again, I think this is an extremely abuse of discretion for a judge to do this, but I've seen a judge who is hearing a defense attorney argue about expiration of speedy trial then, quote, technically start the trial by making one ruling on a motion in limine and then essentially saying, okay, now speedy trial doesn't exist, and then setting the case out for several months. That, I believe, is an abuse of discretion. I think they're overstepping what is required. And so, nevertheless, speedy trial, when you're out of custody, is 90 days for a criminal case in district court in King County. If you have any questions about that or any other thing related to DUI defense, visit us at Webb Attorney, WEBBAttorney.com, or SeattleDUIPros.com. Give us a call, 425-398-4323. All right, thanks a lot.